20 ways to get a work permit under the Biden administration. In this video, I'll talk about the 20 ways that could qualify someone for a work permit. And basically, I'll go over the instruction forms, and that way you can see the category under which you can apply for a work permit. Bijoux.ngwanda, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. Not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss anything. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. Let's get right into it. So the first category first, asylum, refugee categories and their spouses and children. Okay, they are qualified for a work permit. Refugee A3 and work, and basically for the refugee, the way they get their status is basically from back home. They come here as refugees. Sometimes the I-765 form is pre-filled for them, but in case it wasn't, then you get here, you file for the work permit and using category A3. Okay, and if you get you enter in the U.S. as a refugee, paroled as a refugee, so you didn't get your status back home, but you got paroled at the border, and you get here in the U.S. as a refugee, paroled, that's when you get into the category A4. You see, A4. Asylum granted, when it's already granted. When your asylum is already granted, the category is A5. When the asylum case is pending, that's when the category is C8. Granted withholding of deportation, or what they call withholding of removal, category is 810. Remember, for pending asylum case, you have to wait now for a full year before you apply for a work permit, but once you do, that's the category under which you will be applying, C8. Okay, let's move along. You see it says here, wait 360 calendar days from the date you properly file an USCIS or the immigration court accept your asylum application before you file for application for employment authorization. We are talking about asylum, pending asylum applications. Okay, and we go under, you see, yeah, I want to put a note here for granted of withholding of removal. You have to file this I-765 with a copy of the EOIR, immigration judge signed order granting withholding of deportation or removal. So you have to do it with that. So, and then we move along. And then they give you special information on when you have to file for asylum within 1 calendar day, unless you have some type of basically circumstances beyond your control that you can actually argue for, you know. And then we go, this is just giving you the, when it comes to asylum, there's a lot of rules, just giving you a lot of explanation. So we're going here. Asylum application under ABC settlement agreement. Again, it's the same, C8. So now we go under nationality categories. Who is qualified to apply for a work permit? A citizen of Micronesia, the Marshall Islands, or Palau. A8, that's the category. And then defer enforced departure, DD, that's most of the time is Liberian. A11. Temporary protected TPS, we have C19 and A12. So which one is which? So for TPS, it clearly tells you when do you use A12 and when do you use C19. You use A12 if we if your TPS application was approved. If it's your initial application, that's when you use C19. So just remember that with TPS, we have two categories: approval and renewal. Renewal goes with A12 when it was already approved. Basically, first time, it goes with C19. And then we have Nicaraguan Adjustment and Central American Relief Act. That those people under this category, they go with C10. The dependent of E1 non-immigrants, C12, you see, they are qualified to apply for a work permit. So if you didn't know, we have a lot of ways that somebody can get qualified. That's why I keep saying 20 ways to get a work permit under the Biden administration. Now we go under foreign student category. Okay, F1, students seeking optional practical training, OPT, in a position directly related to the major area of study. Pre-completion OPT, that's when you have C3A as a category. Post-completion, C3B. Then we have the 24 months extension for STEAM students with a degree in science, technology, engineering, or mathematics, C3C. That's the category under which they can apply for a work permit. Remember, with student, a lot of requirements must be met first. Okay, you have to go through it and read it. Today, I'm just going ahead and talking about who's qualified. I'm not talking about really the details of the requirements. Then we have F1, student offer of campus employment under the sponsorship of a qualifying international organization. Those people will get under C3 II. Then we have F1, students seeking off-campus employment due to severe economic hardship. Remember, if you're a student and you cannot afford the fees and you can prove extreme hardship and you want to work outside of the campus, you can actually ask for a work permit and see if they are going to offer you that. But once you apply, this is what you are going to apply under C3 III. Okay, so and then we have J2, spouses or minor child of an exchange visitor, C5. M1, student seeking post-completion OPT after completing studies, C6. And then we go under category for eligible dependent of employees of diplomatic missions, international organization, or NATO. Dependent of A1, those are people who come here for diplomacy reasons, working at the embassies, international organizations, stuff like that. So they're dependent A1 or A2, foreign government official, they go with C1. Dependent of G1, G3, or G4 non-immigrant, they go with C4. Dependent of NATO 1 through NATO 6, they go to 6, 7, and it actually gives you where you're gonna go ahead and apply for those forms. It even gives you the address right here. Okay, so employment-based non-immigrant category, so that's when we go with B1, non-immigrant who is personal or domestic servant of a non-immigrant employer, they go with C17I. And then B1, non-immigrant domestic servant of a U.S. Citizen, C17 II. Those are people, let's say they come here and they're working as maid, housekeeping jobs, or some other form of jobs. They can get those work permit and applying under C17 II. Non-immigrant employee by foreign airlines, okay, C17 III. Well, basically someone who's working here as a flight attendant or something to do with airlines, but it's a foreign airline, and they want to apply for a work permit, well, of course, they need to have a work permit in order to operate here, and that's the category under which they will apply. Okay, so then we go to spouse of E1 treaty trader, E2 treaty investor. Remember, we've talked about E2 visa, when you can really show substantial, invest a substantial amount of money in a US based business. Money must be put at risk. That's how you get the E2 visa, basically. And then if you're a spouse of a person who has that E2 visa, then of course you can apply for work permit and work one, not just for the business, but you can work for other companies as well. So then we have spouse of L1 intercompany transferees, A18. Those are people who come here, are working for they were working for an American company overseas, or a subsidiary company overseas, and now they transfer here in managerial positions. Well, of course, the spouse can get a work permit, and then pretty much apply under category 818. Okay, and then we have spouse of E2 Commonwealth of Northern Mariana Island, investors, C12. Then we have and then we have principal beneficiary of an approved employment-based immigrant petition facing compelling circumstances, C35. Well, that's when you have to show eligibility, really, because you're facing compelling circumstances. Okay, and then gives you the renewal, how to do for a renewal. All the instructions are here. And then supporting evidence by principal, what the principal is going to show as evidence. Okay, spouses of unmarried child of a principal beneficiary of an approved employment-based immigrant petition, that's when they go with C36. Remember, we're under employment-based category now. Okay. Some other family-based non-immigrant category, K1 non-immigrant fiance of a U.S. citizen, or K2 dependent, they go with AC. Remember, if you bring your fiance here, first you have to be a U.S. citizen, must have known the person by the time of application 2 years prior the application. Of course, there's exceptions, but remember, you're gonna go with A6. But if you have a pending application for adjustment of status, you should go with C9. Okay, that's when somebody's doing a pending adjustment of status based on marriage. Well, C9 is the category. Remember, a person who's applying for marriage can get a green card, will eventually get a green card, but in the meantime, they can work by applying for work permits at the same time when the adjustment of status is pending. So they go with C9. That's why I keep telling VAWA petitioners, if you want to get a work permit while you're still waiting for everything to be approved, then you should file together with the adjustment of status, because visa is immediately available. Well, at that point you go with C9, because if you just wait for I-360 to be approved, well, it can take, especially with the Vermont Center, it takes between 10 months to 20 months, almost 2 years. So, but if you combine the application with I-360, I-485, and I-765 for work permit, and put under the category C9, then you can get your work permit while your case is pending. Then we have K3 non-immigrant spouse, U.S. citizen, K4 dependent, they go with A9. Family Unity Program, A13. Life of Family Unity, A14. V1, V2, V3, A15. Adjustment of status, under section 245 C9, especially that's pretty much family based. Continual residency C16. And then we have legalization temporary resident pursuant to INA section 245A or 210. They go with A2 and 8 or 9. And non-immigrant, they go with A7. Application for cancellation of removal, they go with C10. Remember, when your application for cancellation of removal is pending, while you can still be working when you still waiting, right? So that's when you go with C10. Application of legalization pursuant to INA section 210 C20, you go with C20. So you show your temporary residency status. Parole C11, defer action C14, DACA C33, final order of deportation C18, including deferral removal under Convention Against Torture. Remember, when somebody goes into removal proceedings and applying for asylum, once asylum doesn't get granted, some people move for withholding of removal, or they move for basically removal under deferral of removal under the Convention Against Torture. So that one, they go with C18. Life legalization applicant, go with C24. That's the LULAC. You have to have evidence that you are a Catholic Social Services League of the United Latin American Citizen or Zambrano class member applicant before October 1st, 2000. Okay. So, and then we have T1, non-immigrant, A16, T2, T3, T4, T5, T6, non-immigrant, C25, T, non-immigrant adjustment of status, C9, U1, non-immigrant, A19, U2, U3, U4, or U5, A20, and then U, non-immigrant adjustment of status, C9, VAWA self-petitioner, C31. Remember, VAWA, as I said before, you can apply 360 VAWA with the I-765, but the thing is, only when the I-360 is approved, that's when you will get the work permit. But if you apply with the adjustment of status and the I-765 application all together combined with the VAWA petition, then you can get your work permit while everything is still pending. So I have to reiterate on that one. Then we have the A3 or G5 non-immigrant, C14 applicant for Commonwealth of the Northern Mariana Islands, long-term resident, C37. Folks, this is it. 20 ways, but it's more than 20s. If you can see how I have been counting those, well, I just wanted to let you know, depending on what category you are under when it comes to your immigration status, you can still get a work permit. If you are not clear where you fall under, what category, please call my office 202-751-2180. Consultation fees apply as usual. But until next time, bye-bye. That was it for today.